Good morning, everyone. This is Arnie Mascali. We'll be starting the webinar in 2 minutes. Please hold. Hello, everyone. We know that people are joining. We'll be starting the webinar in about 2 minutes. Please hold. Good morning again, everyone. We're about a minute till we start the webinar, so we'll be getting started shortly. Thank you. Well, we have noon here Eastern, 9 Pacific. We're going to wait just a couple more seconds for people who are joining on the web. Thank you all for joining. Just hang on 1 second. Okay, good afternoon for those of you on the East Coast. Good morning to those on the West Coast. Thank you all for joining us today. I am Arnie Mascali, the president of Procore Solutions and Consulting, and I'm pleased to moderate a panel of insurance experts who I will introduce in a moment. We're going to start with just a simple disclaimer about this program. But I wanted to start it also to address the sensitive nature of our discussion topic. We're insurance experts, and we're going to be addressing some, but clearly not all, of the insurance issues and potential challenges likely to be considered in a sexual abuse claim. But let me just start by saying nothing we say, nothing in our tone, and certainly nothing implied in any of our comments should in any way be misconstrued as being insensitive to or uneducated about the terrible trauma associated with sexual abuse of anyone, no less children. So with that, I'll make a general introduction and we'll kick off our program. So as you see on the first slide, we're going to talk about some general topics regarding challenges related to sexual abuse. Again, we know that some organizations are facing abuse claims from decades ago, and they're dealing with a perceived violation of trust. Our sincere hope is that all organizations take steps necessary to prevent or avoid abuse. But the reality is that abuse occurred and continues to occur, and organizations must understand their liability for that abuse and the potential that insurance may be impacted by these claims. Also, because of the nature of our work with some clients and organizations, our panelists will not be referencing any current matters, anything that we're handling currently or have in the past. Nothing we say should be taken as commentary on a client matter. If there are any similarities, they are purely coincidental. And finally, before I get into how the states are addressing these claims, just wanted to mention that there are different level of experience on this topic on the webinar today. So we designed today's presentation to be informative at some basic levels. And we invite anyone with specific questions to contact us in confidence to address the more complex or unique issues that you or your organization may be facing. So we know that some of you have already been dealing with these issues, others may be addressing it for the first time, or some of you may be hearing about this for the first time. So we invite you to contact us. Our contact information is available on the last slide. So with our presentation framed by those comments, please allow me the opportunity to introduce our panel, and then I'll get into how the states are addressing these claims. First, Sherry Pastor. Sherry is an attorney and partner at McCarter & English, where she chairs the insurance recovery practice. McCarter is the oldest and largest law firm in the state of New Jersey. Sherry has more than 30 years of experience as an insurance recovery expert, and she's been recognized as one of the top insurance lawyers in the state of New Jersey. We also have Dara Patel. Dara is the president of American Claims Management, which is a national third-party claims administrator. Under her leadership, ACM has handled abuse and molestation claims for organizations across the country. And Dara has done it from both the insured and insurer perspective. So she gives us a diverse perspective this morning. Okay, so how states are addressing these abuse claims. I'll start it off and then we'll kick it over to our experts. But some statistics. Since 2002, nearly 75% of the states in the United States have either modified, amended, or changed their statute of limitations for sexual abuse. More recently, several states have been considering revising their statute of limitations for civil claims related to childhood sexual abuse, thus exposing organizations to liability for abuse by someone within their organization. New York debated that point for years in its state legislature, and recently passed law does in fact address the statute of limitation for these claims. Importantly, one aspect of the New York statute is the quote-unquote revival of claims that may have been barred in the past on the statute of limitation grounds. And that's what we're going to talk about for a large part of today. New Jersey has passed similar legislation. The effect of these changes, which not only in New York and New Jersey, they're occurring all across the country, is that a window has been created to revive or permit claims from decades ago. New York's law allows older claims to be filed for 1 year after a moratorium period, and their 1 year period starts in August 2019 and goes to August 2020. The New Jersey statute has a 2-year window beginning in December 2019. And as I mentioned, other states have similarly changed their statutes. Arizona, Montana, North Carolina, Rhode Island, Vermont, Washington, D.C., all of them have different look-back periods. And still other states have extended their statute of limitations for 30 years or more, which in effect allows claims from decades ago. So you should anticipate that if your state hasn't already followed suit, it probably will. And of course, each state statute is different and should be looked at separately and distinctly. So clearly the liability for institutions and organizations for sexual abuse has risen, and it's significant. You add to the exposure the fact that in many cases, the alleged perpetrator is dead. The administrators or the officers of the institution, they're also dead or long gone. And I think we all probably can predict that record keeping from years ago leaves much to be desired, whether there are hard copies of files, if they actually exist, insurance policies from decades ago. All of this creates a significant challenge for any organization. A couple words of caution as we continue on. Simply because your organization has not had claims made about it in the past for child sexual abuse, don't be misled into thinking that there is no potential liability. One reason is that mandatory reporting laws did not become widespread until the mid-1970s. So there could be claims that pre-existed those laws. And even more so, professionals advise that, well, very often victims of sexual abuse simply don't report the abuse, or they only discuss it with their therapists out of either fear, embarrassment, anxiety about reliving the abuse, for many reasons. So simply because your organization has not yet had to deal with this doesn't mean that it won't. So today we're asking our experts to speak about insurance potentially available to organizations for that liability, and how to investigate, examine, and handle claims brought against those organizations. So I'll kick off with some general considerations, as you'll see on the next slide. What you should think about if your organization is dealing with these issues. First, responsible leadership. What do I mean by that? Well, for those organizations with a past documented history of abuse by one of their employees, any new claim must be addressed with care. I would say things like public apologies, acts of contrition, statements to constituents, they must be guarded and approved by counsel, and I'm sure Sherry will agree later on. However, at the same time, I want to stress, be careful about a callous or an insensitive or a tone-deaf response. Those kinds of responses often lead to anger and, quite frankly, raise the likelihood of litigation and perhaps even incite others to bring claims that they might not have before that response. So this is not an easy balancing act. We suggest what we're calling responsible leadership, treating all claims with respect and dignity, with a calm and sensitive approach. And here's why. Remember that how you deal with the current claims, even from decades ago, will say a lot about your organization today. And be assured, your community is watching how you deal with these claims. Address them quickly, fairly, and compassionately, and your community will trust you. Cloak and dagger responses, well, that's only going to cause your community to be suspicious of you and of further communication. So that's what we're calling responsible leadership. Second, you may want to consider reassuring your community because they're watching. So you may consider describing how your culture is today and how that culture and how priorities now have changed to help avoid or prevent abuse in the future. So discussing preventative measures that you've taken, the policies for communication, perhaps your reporting requirements, even the professional services that you've engaged, your training, all of that. Definitely reassure your community that you've created a culture that protects children and would not tolerate such awful behavior now. The last 2 points, perhaps obvious. Know the law. It's imperative that any and all allegations or credible suspicions of abuse be reported to the appropriate authorities. I suggest this isn't the time for an organization's CEO, executive director, manager, perhaps head of school, insurance risk manager, or some other leader to make decisions on their own. The organization's inside or outside counsel should be consulted about the mandatory reporting requirements triggered by a simple notice of abuse claim. Here, I think we've all seen the very public criminal penalties sustained by organizations and their leaders personally for failing to follow these mandatory reporting requirements. At the same time, you must consider the privacy of all those individuals involved. So be very careful with all communications. We're going to talk about how to handle these claims throughout this presentation today. Clearly, you need to handle them thoughtfully. Don't make the mistake of handling these claims like other liability or casualty claims that you may have experienced in the past. Make sure you have people with experience with these very types of claims on your team. So with that background about some of the considerations, I'll turn it over to Sherry to talk about some of the insurance issues that she sees right now. Sherry?
Thanks, Arnie. The insurers have, generally speaking, been reluctant to provide coverage for these claims, and a number of lawsuits have resulted. Some of the issues that we've seen in connection with those claims previously are what we're anticipating we will see in connection with upcoming coverage suits, particularly where when the windows reopen and claims begin to be presented. So the first issue is going to be probably trigger of coverage. That is your policy activated to respond to a particular claim that would be otherwise covered? And most insurance policies are triggered by what is called an occurrence. It's understood and defined in many policies to be an accident. And so the theory has been that, and most courts have presumed, that where you have sexual abuse of a minor, it isn't an accident, at least by the perpetrator. That, of course, doesn't answer the question about the employer or the entity that may be responsible for hiring or supervising or retaining that person. Often, policies will have what are called separation of insured provisions, so that whether there is an accident can be understood and viewed from the perspective of each insured. Ordinarily, courts have been open to the concept that where an employer or other organization is responsible for the perpetrator and is sued for supervision, retention, failure to warn, allowing the person to continue working or serving in a particular capacity, that there is an accident as long as the perpetrator, if you will, was acting and departing for their own personal reasons when they were abusing, and that conduct wasn't condoned or tolerated by the institution. And more often than not, what comes up here is, was this an accident versus something that was expected or intended by the institution? There have been cases, including in New York, that analyze it. By the way, if there's any case I mention and you'd like the citation, just send me an email. I'm happy to send it to you. But cases that have discussed it are RJC versus Franklin out of New York, where a spa employee assaulted someone, and the court agreed that having done so intentionally did not somehow mean that the institution or their employer did not have coverage. In terms of the additional cases, there's Minnesota bankruptcy court case that related to the Diocese of Duluth that likewise found there to be coverage. In looking at trigger, what the courts also look at beyond is a policy going to respond, they will then consider which policies over time, if the abuse has taken place over multiple years or to multiple victims, ought to respond. And ordinarily, the courts are not in agreement around the country about what tests they apply. Some will apply an exposure trigger. That's when the injury was first caused. Some will apply what's called a manifestation trigger, when the damage or injury to the victim resulted. Some courts have considered continuous exposure triggers, where a policy like the example of the language quoted above refers to continuous or repeated exposure to harmful conditions, and some have applied injury in fact triggers when the injury occurs. There have been cases in the sexual abuse circumstances applying these types of triggers. As I said, the Minnesota bankruptcy case involving the Diocese of Duluth determined that the claims were an occurrence when the victim was abused. There were cases out of Pennsylvania relating to Penn State and Sandusky, where the court held that a manifestation trigger would apply under the theory that someone who's been physically violated or had bodily injury of this type manifests injury immediately, even though the harmful effects may continue. There are also decisions that look at whether this is some sort of continuous event. What I would and I will tell you that there have been cases that have said, at least in the sex abuse context, that they have been disinclined to find continuous triggers, mostly because the view was that when a policy refers to harmful conditions or circumstances, that really is relating to some sort of a phenomenon like asbestos fibers in the air, lead paint in a building, some sort of heat or moisture, but not necessarily a person. So it remains to be seen, what happens in terms of trigger on these cases. A related concept is going to be, now that you know that you have an accident, how many accidents or occurrence do you have? Because policies will often cover, for example, you may have a policy that says it's a $1 million occurrence policy, but it has limits of $10 million or up to $10 million. So you can have multiple occurrences covered under a particular policy. A lot of whether and the number of occurrences there will be is going to be driven by policy language and whether the policy language aggregates those incidents. So on the slides, you'll see that there may well be provisions that talk about having all exposure to or events resulting from similar conditions being deemed one occurrence. Courts around the country differ on what type of test they will use absent that kind of deeming language. For example, New York uses what's called the unfortunate event test. New Jersey uses what's called the Appelman rule. Other states use, effect tests as well. So you're going to need to look at the applicable law because that can have varying results. In New York, there's a case that was decided about 5 years ago, the Roman Catholic Diocese versus National Union, where at least in New York, it was the court's view that there were multiple occurrences where a minor was abused over 6 years. There were actually 7 policies in place over the policy period. It held each was triggered, but by virtue of the fact that the minor was abused at different times and in different locations, the court held that just because there was one victim and in that case one perpetrator, that was not enough for it to be a single occurrence. There were multiple occurrences. Other courts have come to differing views. In California, in the State Farm case, the court's view was that there was one occurrence because although there were several children at a daycare facility molested, the court found that the occurrence was the failure to supervise and decisions around failure to supervise appropriately, such that that decision subjected children to repeated molestation. There are cases, that Minneapolis case that I mentioned with the Diocese of Duluth, that found that there would be one occurrence per victim, even though there was, it might be a single perpetrator, although it did allow for the possibility that if a victim was abused by more than one perpetrator, it would be the number of perpetrators would dictate the number of occurrences. What I would say is, as you think about this issue, think about the implications the number of occurrences can affect your limits. If you have more than one occurrence, you may have the ability to get more limits, but likewise, it can also affect your deductibles. Often deductibles are also on an occurrence basis, so if you have 2 occurrences, you may have 2 limits, or 2 self-insured retentions. The other issue that many expect to come up, and it's already come up in other cases, and seems to be probably what will be a kind of a central theme of these cases is, was there an intentional act? Now, as I mentioned, insurers often will argue that even if they have an exclusion in their policy, by virtue of having coverage grants that require accidents, that the burden of proof should be on a policyholder to prove that what happened was an accident and not expected or intended. It is often the case that policyholders will argue that if there is an exclusion, that the burden of proof on the exclusion is the insurer's and not it. But as you may have seen from some of the recent case filings, the Archdiocese of Newark recently filed suit, and in its complaint, which is against dozens of insurers, it notes that one of the central themes of the insurers in refusing to pay some of the CVA claims that have been filed before the window opened in New York, and some of the $65 million it's already spent on an independent reconciliation compensation program are excluded from coverage because of the notion of expected and intended. In that case, I expect what will also come up and be a theme of these types of litigations are the fact that the policies in many of those cases by those insurers actually contain assault and battery exclusions. And so I expect that there will be a lot of discussion around the fact that those exclusions seem to make clear that if there was an assault or battery committed by one insured, it should not impact the coverage of other insureds. And so the theory, the upshot being, if the policy covers an assault committed by virtue of the negligent supervision retention of a perpetrator, that the expected and intended exclusion would not be treated any differently, that the institutions would have coverage. In terms of the tests, courts typically apply either objective or subjective tests, looking at whether the person intended the conduct and intended the harm. Most often, those exclusions are upheld in the where it's a perpetrator as against whom the allegation is being made. The other thing I would note is, if you haven't seen those, there is often focus on whether the institution itself could be liable in respondeat superior for the perpetrator. And the reason that I bring that up is a fair number of policies with intentional act exclusions limit those exclusions so that they require an insurer to defend and indemnify unless there's some sort of a final adjudication, sometimes in the underlying case, that there was liability or something expected or intended or intentional about the conduct. So where a company or employer or institution can't be liable for the employee, those exclusions may not have applicability. And I would note that New Jersey recently in June issued an opinion that our Supreme Court in New Jersey talked about the fact that if a coworker had no duty to report because that coworker, based on the facts, had no reasonable basis to know that a worker was in a sexual relationship with a minor, then not only was the coworker not responsible in tort, neither was the employer liable for that particular coworker. Some policies will actually contain sexual molestation exclusions. Those policies tend to be more recent policies and not the historic policies. There are court cases upholding these exclusions. The rub really is, does the exclusion apply to all insureds, or does it only apply to the perpetrator? A lot of those decisions that examine these exclusions will be driven by the language. And on the slides, you'll see I've included some language. Does the exclusion bar bodily injury caused by an insured, the insured, which could mean just the person who perpetrated it? Does the exclusion contain language limiting it? Does it go on to say that it applies, for example, only to bodily injury inflicted by you or directed by you, such that if you're the institution, it may well be that the exclusion would not be applicable to your circumstances. There are some cases that have addressed the exclusions. There's a fairly recent Ohio decision from 2016, Encompass v. Edwards, that applied the exclusion to the perpetrator and the parent, where the exclusion did not have the limiting language about inflicted by you, directed by you. And the allegation was very specific to bodily injury caused by molestation and not more broad, such that the court felt that the exclusion applied to all of the allegations as pled in the complaint. I would contrast that with, for example, the First Circuit in 2014 considered the same exclusion and found that it only applied to the perpetrator and not the insured, because the second sentence of the exclusion made clear that it was only applied to someone who had actually inflicted the bodily injury, committed the molestation, or directed it. So language matters when you're dealing with these claims. These are not the only exclusions. There are others that are going to be in play. You may have seen that Drexel University recently filed suit against its employer, its insurer, United Educator. The issue there was it was a policy they're suing under that is a sexual molestation coverage policy, but nonetheless, United Educators, at least in that context, is arguing that other exclusions should apply, for example, those relating to professional services and the like. So in terms of dealing with these issues, jurisdiction is important, but language is as important. In terms of what do you do now after you've read your policies, you've collected them, and you have multiple policies, they're all potentially triggered. How do you divide up the loss if there are multiple policies triggered? Again, courts around the country, some have dealt with this and have developed rules for how to allocate or divide the liability. And in terms of that, you'll want to kind of bear in mind what kind of state you're in. In New Jersey, the courts use a pro rata by times and limits approach. In New York, the default approach, unless there's policy language otherwise, is pro rata. What that means is if you had two triggered policies, you would divide by two. They would each pay their proportionate share. In New Jersey, pro rata by time and limits not only takes into account how many years, but how much coverage you bought. So by way of example, if you had two policies, unlike New York where you do 50-50, a court would look at how much were the limits. So if you had one that was $5 million in limits, another that's $10 million in limits, the first pays 1/3, the second contributes 2/3. As I mentioned, in New York, depending on your policy language, you may have policy language that requires the court to have an all sums approach. California also allows for an all sums approach. That permits the policyholder to collect the total liability under any one policy in effect during the policy period. So policyholder chooses the insurers, and then the insurer who is paying, if it feels it has overpaid, has the burden to go out and get contribution from other triggered insurers, but that obligation does not fall to the policyholder. In states like California, you can also stack policies so that you can maximize your recovery. In terms of the allocation, and you'll want to be thinking about when you're trying to allocate among multiple policies, actually finding those policies, whether it's by resort to, if you can't find them, your broker, your canceled checks, bylaws, past claims, other insurance claims that you've filed, other lawsuits that you've filed. So as an organization, you're finding the coverage that may well respond to allegations against you for the appropriate periods of time. Dara, why don't you talk a bit about claims?
Yeah, absolutely. Thank you, Sherry. That was great. To add quickly to the last slide in terms of allocation, I will say a good claim strategy starts by conducting a thorough research of the insurance history, not just, of course, for the basic, part of you want to make sure everything that's triggered is tendered timely and reported timely, but really to make sure we know from when we're representing an insured what policy language, notations such as the ones that Sherry has just gone over could be triggered. It's super important to keep all of those in mind while you're formulating a claim strategy once claims are reported. In terms of overall claim strategy, in our experience handling these similar types of claims for many years, it's simple and extremely complex, as a lot of things are in this subject matter. The simple part is there needs to be an outside perspective and an inside strategy. The outside perspective, of course, is that we maintain extreme sensitivity, that any person that's communicating to claimants, to their attorneys, to brokers, to the media is authorized to communicate on behalf of the policyholder. And when that person is, that they are, maintaining that we are doing a very thorough investigation. We're extremely sensitive and take these matters very seriously. So that is, of course, the outside presentation. The inside presentation is that it is extremely important to do an aggressive investigation. In our experience, a lot of these situations, unfortunately, do end up being a person versus person stories and who said what and who remembers what. And an aggressive and thorough investigation can really help us and our clients determine and piece together what realistically happened and what the merits of a particular claim are. So in terms of overall strategy, we recommend an extremely hands-on approach, a very comprehensive witness search. Many times we'll start with a list of witnesses that we are given by both parties that may be involved. And I can tell you almost all of the time, by the time we're done with our investigation, that witness list has doubled, tripled, gotten much larger, because every time you speak with a witness, there are other names that are mentioned or other witnesses that are mentioned. And it's extremely important to follow every single track that comes up, no matter how many different directions it goes in, because something that one fact or one witness that can be overlooked can end up, making a significant impact later on if we don't know about it first in our investigation. We highly recommend utilizing experts that are very good at in-person investigation and interviewing. These are not the kind of statements or investigations you want to do via phone. You get a much different, I would call it sort of perspective when you're meeting with either the claimant, their representatives, or even our clients and their representatives, especially when it comes to establishing who's going to be credible and how they are going to present, whether it's in a deposition or a mediation or a trial if that comes into play. So that aggressive, I would call it leave no stone unturned investigation, so we know everything hopefully before the other side does, is extremely important, as is conducting that in-person investigation with the specific expert to establish credibility. In terms of the next area I wanted to cover, that would be using and utilizing the right claims resources to help us. We, for example, have an in-house investigation SIU unit that can actually conduct extensive background checks on all parties. That is as important to run on our clients and the principals that we're working with or anyone that's involved in the client as it is on the claimant side of it. It really helps us, get a big part of the piece of the puzzle together. It is also extremely important to review all records and reports that our clients have. We actually always insist on sending one of our experts on site to work with the clients, and whether it's their risk manager or their HR department or their broker, whoever they designate, but we believe it's very important for us to actually be on site reviewing all documentations, notes, logs, correspondence that they have in their possession. Oftentimes, we have learned that if we rely on a client to go through the notes, logs, and correspondence on their own accord, they may not realize that something could be important because they may think it's not directly related. But after unfortunately handling hundreds and hundreds of these kind of claims, we believe it's very important for us to be on site looking at everything and identifying what we need to bring back as part of our claim file. There are actually quite a few technology tools that are available to us now that we often incorporate in our investigations. Detailed online and database searches really help with not only background checks, but really being able to piece together a person's employment history, for example. The technology tools help us track down witnesses that could, of course, have moved around many times and no one knows where they are. And then social media canvassing can help quite a bit. SIU departments have access to many different government databases and public forums that we can use technology to actually canvass and save a lot of valuable time in gathering that information. I'm going to actually turn it back over to Sherry here for the next couple of slides to talk about prior related claims, and then I'll kind of conclude with some claims resolution strategies.
In terms of the claims, there's an expectation that statutes of limitations and windows statutes are being extended, windows are being opened, that there will be multiple claims. And so you may have a victim 1 and victim 2 send in a claim or file a suit which will implicate provisions in the policy that relate to related claims and relations back. And on the slide, you'll see some sample language that comes out of a policy that basically says where you have a claim that's arising from the same wrongful act, and there are multiple claims, that they're going to be deemed a single claim, and it'll be deemed first made at a particular time, whichever is earliest. So when the first claim of 2 or 3 or many more come in, or when notice of circumstance was given of a particular event. These types of policy provisions bear on when a claim is first made. They can be important in a claims-made context where your policies are going to cover claims when they are made, regardless of when the acts giving rise to those claims took place, assuming, again, that when you bought the policy, the act wasn't known or you're within the retro date. The way that courts have addressed these provisions are often to look at whether the claims are logically and causally related by facts or circumstance, and where they are, the claims will be treated as a single claim within the earliest policy. And the reason for that is essentially insurers will argue that they don't want to have two limits in 2 different years, for example, exposed by claims, and that the second claim will relate back to the, in terms of when the claim is actually made. Now, what I would say is beware of these types of provisions and insurer arguments associated with them. Just because 2 or more claims are deemed related in terms of determining when a claim was made does not mean that they are deemed related for determining whether exclusions apply. And in fact, there's a fairly comprehensive decision out of Washington by Judge Jones in 2013, noting how just because these provisions will apply to when a claim is made has nothing to do with the exclusion, because each of the claims will be looked at separately from an exclusion perspective. Another claims-related clause that sometimes comes up is what's called the non-cumulation clause or provision. And this is one that is, again, by insurers seeking to limit how much they're going to pay under occurrence policies most often when multiple claims come in. And a provision like this will note that the insurer's total damages are not going to exceed a particular amount, no matter how many persons are involved or how many insureds are involved or how many suits are filed. You'll want to bear in mind that these provisions rarely come with the title non-cumulation clause above them. In looking at them, courts have varied on how and whether they will uphold them. There have been some courts that have upheld these types of provisions. There have been others that have held that they are void against public policy if the provision is what the court considers an escape clause, where, for example, the insurer is suggesting that the damages it pays is reduced by what a prior insurer, a different insurer, is paying. There are some jurisdictions that have also held that, at least in allocation in other contexts, these clauses don't apply because of the allocation method being used by the court. But the other context in which these clauses can come up are, this was kind of the exception that the New York court made to its default position on pro rata allocation. By virtue of a clause like this, the court in Viking Pump said, you know, the policyholder gets to choose the policy under which it's going to allocate its loss. So you'll want to be on the lookout for these types of clauses when you're analyzing your coverage for sexual abuse related claims. Dara, why don't you talk about some claims resolution issues?
Sure. Thank you, Sherry. So yeah, in conclusion, when it comes to claims, we find that the best resolution strategies are really to make sure, like we've talked about, that a complete investigation is done early and quickly, and that everyone is in collaboration and communication at all times. So one of the big things that we do recommend, like I've already talked about, is to establish who will be speaking on behalf of our clients, who's authorized to speak. Unfortunately, these are not the type of situations where we recommend that clients say things like no comment or authorize not to comment. That usually ends up being viewed as pretty negative in the media and by the other parties. And so we actually recommend taking a different approach, which is established uh, uh, people who are comfortable speaking to the outside world and are completely informed at all times with the global communication strategy that everyone's agreed to. Investigate everything and everyone. It's definitely one of these areas where we want to know the bads and the goods, but especially the bads before the other party does. And that thorough investigation really helps us with that. Establishing a very detailed timeline and a witness list that talks about the credibility of each witness helps with the overall understanding of where we need to go onto a claim. That really is a situation where offense can be the best defense if we know we have an internal witness that, although may have a lot of facts, will have issues when they're presenting or will have credibility issues. It's something we have to factor into the claim strategy. Um, Evaluating exposures early is extremely important as well. I mean, you're going to have cases that we often recommend are settled early just because of the facts not being in our favor or witness credibility issue. And then there are going to be, many claims that come in where we recommend an aggressive defense strategy because the credibility is in our favor, and our investigation has revealed enough to show that our clients actually have a very strong case. The number one thing that we definitely encourage is just constant communication, making sure that everyone is on the same page, full internal transparency, and making sure that everyone has a united front, really, when we're dealing with the outside world when it comes to claims. With that, I'm going to turn it over back to Arnie to talk a little bit about how organizations are already responding and what we're currently seeing.
Great, Dara, and let me just thank both Dara and Sherry for a really comprehensive view on some of these claims issues. What I wanted to talk about right now and just conclude and then open for questions is just how some organizations are already responding. We could use this as a guidepost in terms of how you or your organization may want to deal with some issues. Certainly not listing everything that they're doing, but some of the more typical responses that we're seeing. First, meeting with the victims. Some organizations have offered to meet and listen to the victims firsthand, allowing the victim himself or herself to describe what happened in whatever detail that they choose. And it may be a lot of detail, it may not be. These meetings can be part of the healing process for the victim, but as long as the proper respect and concern is shown during these meetings. Obviously, no means should this meeting become a question and answer session or anything that resembles an inquisition or that you're questioning whether the abuse happened or not. These meetings ought to remain confidential. Only a small number of people from the leadership of the organization should be involved. And clearly you want to just give the opportunity for the victim to tell what happened to them. Other organizations have offered to pay or provide professional counseling, therapists. Some organizations have actually been very successful in creating and supporting these kinds of services. What it does, it demonstrates a sincere concern for the victims. It helps them deal with the long-lasting effects of the abuse. But here I would recommend highly that a claims administrator, just like Dara and her company, should be involved. It would be helpful to help them have them manage the process, make sure it's fair, make sure obviously the therapists are keeping all the information confidential, so that there are no suspicions later on that this was, you had some other intention here by providing these professional services. Clearly, you want to turn that over to a third party. Where there are cases of, if you have credible or documented abuse from the past, some organizations have already decided to offer monetary settlements to the victim. Again, here, please be careful about entering into any discussions before you've had conversations with your counsel, certainly your insurance counsel. I'm sure Sherry would tell you to work with your counsel to make sure you understand all the implications of a settlement offer or even just a settlement discussion. Make sure you're aware of what the implications may be to your insurance if there is any insurance available. Other organizations that have had a documented or well-known or widespread allegations of abuse from decades ago, some of those organizations have created what's come to be known as victim compensation funds, and those funds are set up to achieve several main goals. One, resolve very difficult, tragic realities from the past with a victim or victims. And you're giving a demonstrable sign that the organization is taking responsibility without requiring litigation or someone to bring a public lawsuit. Also, it assures your current community that you have integrity for even things that may have pre-existed the leadership of the current organization, but you're taking responsibility for past conduct. Again, take the opportunity to tell your community that you're now protecting them from any future harm, that you've taken steps to, hopefully avoid or prevent abuse in the future. But also, these kinds of funds can help to protect the organization's financial viability. Clearly, it's obviously in everyone's best interest, especially for not-for-profits, nonprofits, whether they're charitable, educational, religious. It's very difficult to depend upon raising funds while there's exposure to various very highly public claims. As Dara just mentioned, you may want to have an outside and an inside strategy. So to the outside world, you want to be very careful when you're setting up these kinds of funds. It's a fine balancing act, and perhaps even a professional communication expert would be helpful here to discuss how the organization is dealing with the past, but really focusing on the future. So we've seen some very successful funds set up, and I think it really goes to what Dara was talking about, being very careful and cautious with these types of strategies. One last thing I want to mention, there is insurance available on a going forward basis. Sherry mentioned that there may be some possible insurance coverage for these types of acts. Be very careful there about the required disclosures during the placement process. You may be required to disclose of known past allegations of abuse. Here, highly recommend that you consult with an insurance broker who's experienced in this area and can help guide you through that process, because you don't want to later find out that there was a disclosure that was mandatory that you did not make. But, if there is insurance coverage available to you going forward and you want to take advantage of it, it's just do it very cautiously. So with that, we're at 55 minutes. First, I want to thank Sherry and Dara. There have been a number of questions that have come in. We appreciate the questions that have come in. We have about 5 minutes, but we're going to start quickly looking at some. I think the first one, actually, it's not directed to anyone in particular, but Sherry, based upon the question, I think it's for you. The question is, this is a basic question, but are these look-back statutes constitutional? Well, I would say, Sherry, that's not actually a basic question. That's a fundamental question. Are these amendments or these modifications to the statutes where you're allowing what's called a look back or a revival, are these being questioned constitutionally?
Yes, is the short answer. The longer answer is there was a similar statute passed in California many years ago. At least the retroactive criminal part of it was overturned as violative of the ex post facto rules. I think in a civil context, those types of arguments have and will be made to the extent the civil look back is regarded as punitive, but probably more important than that are going to be the challenges around separation of powers, where you had claims that were finally and fully resolved by the court on statute of limitations grounds, and now have the legislature effectively coming in and disturbing what would have been a final judgment. So I think you'll probably see some challenges, at least in the underlying claims to that, and probably in terms of the insurance, if all bets are off, probably all bets are off in connection with those prior claims.
Okay, thanks, Sherry. And Sherry, there's actually a number of questions that are coming in from a legal perspective. So there's a couple of questions regarding claims handling. I'm going to invite anyone who has specific questions to any of us at the end. Well, again, we'll give you the information. You can contact us directly. Dara, real quickly though, there seems to be a number of questions about, you talked about can you talk about the most effective claims strategy? You've mentioned a number of ways, Dara, to handle some of these obviously very sensitive issues. What have you seen be the most effective strategy in dealing with these?
Sure, yeah. I would say it's really sort of twofold. The first one is to move as quickly as possible. The more we know, the faster we know, we can get ahead and devise a real claim strategy and really determine if it's a matter that should be settled or if it's a matter that should be, challenged and litigated. So moving quickly, and the challenge becomes really working with our client and having them help us move as quickly as possible. That leads to the most effective resolution. And the second is probably just going to be getting everyone on board. Where our investigation, a claims investigation, is going to reveal things that sometimes the clients themselves aren't ready to handle. And we try our best to make sure everyone is on board, understands what the ramifications are in the future. And as long as there's constant collaboration and communication, we think that the claim strategy will be extremely effective.
Great, Dara. Sherry, there's a number of questions. We only have about a minute left. There's a number of questions about trigger coming in. What I'm going to do is, first of all, I want to thank both Sherry and Dara for what I would call a really comprehensive hour on this topic. Hopefully, we provided some basic information and some more in-depth information for all those that are listening. If there are specific questions, like for example on the trigger question, we certainly invite you to reach out to Sherry, to Dara for claims handling. Feel free to contact me, and I'll make sure I get you to the right expert. On this last slide, we have our email addresses. It's probably the best way to reach us. Reach any one of us, and obviously whoever is the right person will respond to the question. We want to thank everyone for their time today. Thank you for your attention. Again, we understand the sensitive nature of this topic. We appreciate the opportunity to bring you some current and relevant information, and look forward to helping you in any way we possibly could. Thanks, everyone.
Thank you.
Thank you.